I think I'm pretty much just going to pick up where George left off with the courts. But I just want to say thank you for having me here. 9/11 was literally close to home for me. I was born in the Bronx. I lost some friends in those attacks and actually worked at the law firm across the street and clerked for the federal court around the street, around the corner. So this is, this is important personally and nationally, I suppose, and internationally. I'd like to make three sort of interrelated points today. It's kind of ambitious regarding the tug of war, or the perceived tug of war, between national security and individual rights that 9/11 sparked. One point concerns separation of powers, which George just alluded to. We talked mostly about Congress and the executive. I want to focus on the political branches, that is Congress and the executive on the one hand and the courts on the other. The second thing I want to focus on is the methodology that the Supreme Court has used to resolve issues in cases involving the war on terrorism. And third, I'd like to try to explore a kind of deeper jurisprudential point about the nature of law. Has what the Supreme Court done in this area upheld the rule of law? So the first point on separation of powers is when we're talking about national security and individual rights and trying to balance these two in a time of crisis, it's not a free-floating policy determination. It's not, I think this is the best way that should be balanced. It exists against a background of separation of powers. The Constitution allocates authority to different branches of government, to the political branches, the President and Congress, the power to declare and wage war, and to the courts, the power to protect individual rights from government overreaching. So what has the court done when faced with the potential of government overreaching? I think, despite the fact that the cases tend to be exceedingly technical and very long, a couple of themes can be pulled out. One is the court has rejected the government's argument that it can, on its own, just cut off individual rights. I think you'll see in the cases, I'll talk about them in a second, what the government tried to do is interpose some label or concept that basically cuts off all individual rights, and the court said, no, you can't do that. The second thing that the Supreme Court did, was develop methodologies for resolving this national security individual rights balance. It didn't say, here's how to strike the right balance. Didn't give a substantive rule that balanced the two. It said, here's how to go about analyzing how to balance these things, and then delegated that task to lower courts, which is kind of an interesting development in the law. So a couple of examples. I think the two best examples of this, and probably the most salient examples from the war on terrorism, are Hamdi versus Rumsfeld and Boumediene versus Bush. Hamdi versus Rumsfeld involved a U.S. citizen who was taken into custody by the Northern Alliance in Afghanistan, transferred to Guantanamo Bay. When it was found out that he was a U.S. citizen, he was transferred to U.S. territory, and the executive said, we have the power to hold you indefinitely. We can just throw you, in a cell, that's it, you're done. Why? Because you're an enemy combatant. And going back to something George said, the President said, I have this authority. Congress passed the authorization for the use of military force, gave me the power to determine who the enemy is. As Commander-in-Chief of the Armed Forces, you're the enemy, and you're done. That's it. We're putting you away forever. And the court said, no, you can't do that. The Due Process Clause of the Fifth Amendment protects U.S. citizens, gives them rights, procedural rights, to challenge the classification by the executive that they are an enemy combatant and detain them indefinitely. Boumediene versus Bush dealt with a somewhat related but different question. The question there was, can the government detain aliens, non-citizens, outside the United States indefinitely without giving them procedures, without allowing them to challenge their detention, more specifically under the habeas corpus privilege in the Constitution. And I'll just say that the President transferred these detainees, these non-citizens, to Guantanamo on purpose. There's a World War II precedent that said, if you're a non-citizen outside the United States, you're not entitled to habeas corpus privileges. It's involving Germans held in Germany after the Second World War. They wanted to challenge their detention in U.S. courts, and the Supreme Court said, no, you don't get habeas corpus rights because you're an enemy alien outside the United States. So the president here said, enemy aliens outside the United States, leave them in Guantanamo, don't bring them to the United States, therefore they won't have constitutional rights. The Supreme Court said, no, they do have constitutional rights. And the label that the executive tried to use there was sovereignty. The executive said, well, because Guantanamo is outside the sovereignty of the United States, these people don't get constitutional rights. The court said, well, you're determining what sovereignty is incorrectly. Maybe we don't have what's called de jure sovereignty over Guantanamo Bay, that is technical or formal sovereignty, but we have de facto sovereignty over Guantanamo Bay. Namely, the United States has complete jurisdiction and control over the base, and because we have complete jurisdiction and control over the base, constitutional habeas corpus privileges extend to detainees there. So the first theme is the court rejected the government's or the political branch's power grabs, basically. And maybe that's even an overstatement. I mean, I don't know that they were necessarily power grabs all the time, and there was precedent supporting what the executive did. The second point is that instead of giving a substantive rule, right, instead of saying, here are what procedures you're entitled to if you're a U.S. citizen and the executive throws you in a cell. Here's what you get. The court said, we're not really sure what you get. You maybe get a neutral decision maker. You maybe get to challenge the evidence against you, but maybe it could be hearsay, which wouldn't be okay in a criminal trial. Maybe there's a presumption against you, unlike in a criminal trial where you have a presumption of innocence. So kind of came up with this fuzzy analysis and kicked it to the lower courts to figure that question out. The same thing happened in Boumediene. The court didn't say, here's where habeas corpus rights apply to non-citizens outside the United States. Instead, the court came up with a test, and the test was a quote-unquote functional approach to when the Constitution extends to non-citizens outside the United States, depending on where they're located, their citizenship, whether they're a citizen of a country at war with the United States, their status, the procedures. As the articulation of all of these tests show, I mean, they're really fact-sensitive, they're really context-specific. And this kind of brings us back to the separation of powers question, which is, before we can even get to this question of what should the balance be, what should the balance be between defending our country and in guaranteeing individual rights, we've got to figure out who should be making that determination. And here what the Supreme Court did is kicked it to the lower courts. It basically said, you figure it out, lower courts. You juggle all of these myriad sort of fact-specific issues and resolve the cases on the particular facts presented. And I'll just conclude by saying that may seem good. I mean, that may seem good, right? We've got a sort of unprecedented situation, a war like no other, if it is a war. It's some combination of warfare and using criminal law. So maybe it's best to move incrementally and the cases will congeal organically into some stable precedent. I can say that hasn't happened. That's sort of on a sort of deeper jurisprudential level a little bit troubling. We want the law to be predictable. I mean, think about your day-to-day life. You live according to the law. If you didn't know what the law said, you wouldn't know what to do. But here, because we've got these sort of lower court, this organic evolution of the law, incrementally it's kind of difficult to figure out how to behave, especially if you're trying to wage a war.